Happy New Year, everybody. I'm Nikki Gilbert Daniels, and I want to thank you for stopping by Worth TV and checking out our new programming. Tonight, I'm super proud to introduce to you a series that we are so proud of, something that we feel is long overdue, and something that we feel will help entertain, educate, inform, and enlighten you. Now, bear with us as we sort of get the kinks out of this new program, but we're so proud to introduce to you product of Worth Media, Worth News. That is news that we believe is worth, no pun intended, sharing. Tonight's program is sponsored by From the Bottom Up Foundation and our new initiative, the Creatives Coalition, addressing inequity in entertainment. The Creatives Coalition, a program of From the Bottom Up Foundation and Worth Media, seeks to establish the Creatives Partnership Act, a legislative and policy agenda that advocates for the creation of more equitable partnerships between major corporations, entertainment brands, and Black, Indigenous, people of color content creators and entrepreneurs that closes the wealth gap by equitably monetizing creatives' intellectual property. IP ownership is key, and its power to change lives has been proven. The board members of Worth Media felt like it was very important for us to have a platform where we could speak from our voices and share news, information, education, enlightenment to our community. I want to thank each and every one of you who helped us reach 15,000 subscribers. We are looking forward to reaching many more of you. This is a series that is a reflection of some of the initiatives that we are pursuing at FromTheBottomUpFoundation.org. If you have not already gone to FromTheBottomUpFoundation.org, please pay us a visit. And if you can, please give what you can.
Thank you for tuning in to the season premiere of Worth News, the online platform that brings headlines Worth Media believes are worth sharing. I'm your host, Clarence Mack. I will be joined by expert Helen McDuffie. Together, we will unpack the latest developments in celebrity courtrooms. Over the past few years, America's passion for courtroom dramas has reached a fever pitch. From celebrities in the hot seat to former presidents facing legal fire to billion-dollar corporations battling independent creators. In this episode, we take you inside one of Hollywood's high-stakes legal showdowns, the battle between an entertainment behemoth and an independent writer, producer, singer, and fierce advocate for creative equality.
We'll discuss a case with the Ninth Circuit Court of Appeals, where the plaintiff has filed a petition to rehear N. Banks, which is still pending. Although this case is crucial to the future of copyright law, mainstream media coverage has been surprisingly limited. Our mission at Worth News is to shed light on these pivotal stories that matter to creators, innovators, and everyone who cares about artistic freedom. We are diving into the details of this David versus Goliath legal confrontation, discussing what it could mean for the broader creative community, and exploring why the outcome might shape entertainment for years.
Our platform is designed to help unravel the big stories and hidden dramas in the world of culture, entertainment, and entrepreneurship. On this episode, we're tackling one of the most pivotal and often misunderstood topics in copyright litigation: how the district courts as well as the Ninth Circuit dismisses cases before they get to a trial, sometimes even without expert testimony.
If you've ever wondered why some high-profile lawsuits never see a courtroom showdown, and how courts decide no substantial similarity before a jury is called, this episode is for you. You have to look closely at landmark cases involving Disney, Zindel, Gregorini, Fox, Led Zeppelin.
Why is this such a big deal? Because if you're a creator, an artist, or even just a passionate fan of pop culture, these decisions can shape the entertainment landscape you love and directly impact the culture.
Also, if you're an aspiring lawyer or a legal buff, understanding the Ninth Circuit's extrinsics test for substantial similarity is absolutely critical if you ever plan to practice copyright law.
I've seen some of the most talked about Ninth Circuit rulings where entire lawsuits got tossed out at the earliest possible stage. This case we are about to unpack is shaping up to be a cautionary tale for anyone who thinks inspiration might cross the line into infringement, and a fascinating look at the boundary between protected creative expression and everyday ideas that belong to us all. Our focus is on Nikki Gilbert Daniels, an accomplished writer, producer, and singer who filed a complaint back in January 2022, alleging that Lionsgate's hit series P-Valley infringed on her stage musical, Soul Kitten's Cabaret. Originally filed in Georgia, Nikki's case was transferred to Los Angeles, where critics say deep-pocketed corporations often have a distinct advantage over underfunded plaintiffs.
In a series of court maneuvers, Nikki believes she was denied the ability to use critical evidence, sworn depositions, including 57 side-by-side video comparisons. Ultimately, District Judge Stephen Wilson dismissed her claims for lack of substantial similarity and awarded a hefty six-figure judgment to the defense. Despite a mounting legal debts of her own and feeling that discovery was cut short, Nikki refused to back down. Determined to fight a ruling she believed was unjust, she took her fight to the Ninth Circuit Court of Appeals, where ultimately left her with more questions than answers. Keep in mind, these are allegations and not final legal facts. The facts surrounding this case are available on Pacer or WorfMedia.com.
For those who can't quite understand the legal jargon or expert testimony, or if you're simply wanting an even deeper look, Nikki shares the raw details in her upcoming book, Nikki vs. Goliath, The Cost of Pursuing Justice, which chronicles her 4-year battle against an entertainment titan. What happened next only made the journey more difficult. Her attorney shared on the morning of the hearing that he was in excruciating pain he believed required hospitalization.
You will notice during the hearing that the attorney could not stand. Despite his illness, Nikki's attorney pressed forward with the oral argument. The hearing we are about to watch took place on December 5th, 2024 in Pasadena, California, at the Ninth Circuit Court of Appeals.
And Counselor, you may approach when you're ready.
Good morning, Your Honor.
Oh, you're going to sit from there?
Yes,
Okay, that's fine.
Housekeeping, I apologize that I...
No, that's...
I cannot hear you speaking, sir, so if you'll pull that microphone to you, that would be great.
It looks like it was off. Can you hear me now, Your Honor?
Yes, I can.
Okay.
Thank you so much.
We represent the plaintiff in this case. She is the author of a play, Soul Kitten's Cabaret, otherwise known as SKC. It is a registered copyright along with the filming of the play, we call it the DVD, that was filmed of the actual performance of the play, both of which are registered copyrights. We allege in this case that the defendants wrote and produced the television show P-Valley, which is at every single elementary level of the Ninth Circuit substantial similarity test, basically a ripoff of plaintiff's work.
First, maybe my biggest question is that it seems to me that the themes that you identify as being substantially similar, such as the, morality issues, good versus bad, choices that people make as mothers, daughters, partners, that those are things that flow pretty naturally from the setting of these two works and are unprotectable. So if you could address that, that would be helpful.
Our expert, Mr. Rob Aft, is, as the district court noted, no doubt extensively experienced in reading thousands of scripts. That's what he does. He reviewed a lot of the films, most of the films in this, let's call it a niche subgenre, and he was able to do exactly what you say, to separate what is and what is not protectable. But even over and above that, there's an important analysis, the selection and arrangement test, otherwise known as the Metcalfe test.
In Metcalfe versus Bochco, the Ninth Circuit recognized that even if individual story elements or ideas like stock characters, settings, or themes are not protectable on their own, the unique way those elements are selected, arranged, and combined can be protectable. In simpler terms, if you take everyday pieces but arrange them in a special, distinctive way, that overall combination might be protected even if each piece by itself is not.
So the key takeaway of the Metcalfe test for substantial similarity is that courts must look beyond individual or unprotectable elements to see if the creator's specific selection and arrangements rises to the level of protectable expression.
Yes, this is a Ninth Circuit precedent, so this should have been considered in the light most favorable to the plaintiff. But let's continue watching.
I'd like to talk about the Metcalfe test briefly because there's this insinuation from the district court that it is either a dying doctrine or something that's hyper narrow. The district court gave, I think, short shrift to the Metcalfe test only to say these are the issues or these are the facts that were at issue in Metcalfe, and a conclusory statement with no analysis to say our facts don't come anywhere near to meeting the similarities in Metcalfe at the selection and arrangement test. First of all, the two most recent cases in the Ninth Circuit that address Metcalfe are an endorsement of Metcalfe. You've got the Alford case, the Pirates of the Caribbean case, and there the court, the Ninth Circuit, stated that an expert might indeed be helpful in separating what might be a mere pirate trope from the rest of the film.
Oh, was it a motion to dismiss stage, I remember?
It wasn't a motion to dismiss stage, but nevertheless, it talked about the importance of why expert testimony might be important. It was Judge Page who wrote that opinion. I believe you clerked for him, Your Honor, and it was that's one where, at the oral argument, he quizzed the appellant and asked, does this mean that we're going to have an expert in every case? And the appellant in that case said, no, but you do in this one.
Senior Judge Paez of the Ninth Circuit Court of Appeals has consistently emphasized the importance of expert testimony in legal proceedings, particularly in complex cases. He advocates for a thorough and fair evaluation of such testimony, cautioning against its unwarranted exclusion.
A lot of the elements we're talking about here are unprotectable elements that are sort of generic to pirate stories. You have
how do we know
Miss
Lloyd, how do we know what's generic to pirate movies?
Well, I think that in
I can't say that I'm schooled in the history and lore of pirateerism or whatever you want to call it, whatever it might be called. How do you know? How do you know what's generic or scenes l'affaire? Scenes affair. How does one know that? So you can say, as a matter of law, there is no infringement here. I mean, that's what I have a hard time figuring out.
I understand that, Your Honor. So,
Judge Paez also highlighted that challenges to the reliability of expert testimony should typically be addressed through cross-examination during trial, rather than outright exclusion. He emphasized that excluding expert reports in their entirety, especially when they offer relevant opinions with sufficient foundation, exceeds the court's limited gatekeeping function.
Judge Paez's perspective strongly supports the admissibility of expert testimony when it is grounded in appropriate methodology and relevance.
So I have a question here because we are examining the exclusion of the expert for abuse of discretion,
yes.
Correct?
Yes, that's the statement.
And there are cases such as Rice, which have upheld the exclusion of expert testimony, particularly where, as in this case, it basically restates the things that were already offered by your client.
Rice versus Fox. Magician Robert Rice sued Fox Broadcasting, claiming their TV special revealing magic copied his copyrighted video, The Mystery Magician. To strengthen his case, Rice relied on an expert who argued that both works were similar because they featured a masked magician revealing tricks. However, the judge threw out the expert's report, saying it didn't prove the character or tricks were unique enough to be protected by copyright. Rice's case fell apart without this critical expert testimony, as the court ruled that generic elements like a magician in standard attire performing common tricks couldn't be copyrighted. This decision hurt Rice's claim significantly and ended the case in Fox's favor. Once again, you have a well-funded corporation winning a court battle over an underfunded plaintiff, and most expert reports can run into the tens of thousands, so throwing them out doesn't seem fair.
In this case, it basically restates the things that were already offered by your client. And I guess I would appreciate your directly addressing Judge Thomas's question about why some of these tropes are not too generic to be protectable.
Sure. Okay, so first of all, the abuse of discretion standard is indeed the applicable standard here. There remains, even post the amendment to Article 702, a liberal thrust towards admissibility. The expert in this case opined that he had studied extensively this genre so that he could separate what might otherwise be perceived as sans-affaire from everything else. Moreover, the expert report goes in, and to address Judge Thomas's question, goes to address the chronology of all the scenes. The appellees will charge that this is just a shotgun approach to a bunch of similarities scattered throughout. It's not the case. Our expert talked about, importantly, that this was in a chronological order, similarity at every one of the relevant elements under the Ninth Circuit's substantial similarity test.
This oral hearing highlights the inconsistent treatment of expert testimony in copyright cases. The panel's reliance on Rice versus Fox contrasts with the Ninth Circuit's en banc decision in Skidmore, which stressed the importance of evaluating expert analysis. Rehearing en banc can establish uniform guidance on the admissibility and role of experts in substantial similarity cases. The case could offer an opportunity to create uniformity because it sounds like Judge Graber is convinced that the same thing that happened in Rice should happen in this case. But let's keep listening.
But I guess, just to follow up on what my colleagues are saying, there's something that sometimes naturally flows from a chronology as well. If a dancer is going to show up at a city as an ingenue, and then there's a character arc to that, you would expect the arrival first, as you were trying to point out in your briefing, a beginning and a middle and an end. But if it's at a high level of generality, how does that start to fit into a Metcalfe framework where it's very highly specific details that seem to be more of a ripoff as you were describing it earlier?
So I would argue that we both meet the test of the regular substantial similarity in addition to the Metcalfe test. It's not like Metcalfe is just a backup here.
After watching the 57 comparisons, I wondered whether a reasonable juror could examine the following list and decide whether it is close enough to the same order and arrangement to pass the Metcalfe test. Remember that each description occurs at the beginning, middle, and end of both, in almost the same order, despite one being a 2-hour stage play and the other an 8-episode TV series. In the beginning of both shows, a lean, wiry, shy, new girl carrying a vintage red suitcase arrives by public transportation. She checks into a seedy motel and needs to find work, so she heads to an erotic dance club to audition for talent night. The new girl is a mediocre dancer but hired on the spot. She is not dressed appropriately. The gender-fluid owner points her to a rack, where another employee hands her a skimpy outfit. The modest erotic dancer changes in the bathroom. Other dancers taunt her. The new girl keeps a secret life back home and doesn't disclose her true self initially. The owner is looking for a replacement for a veteran dancer who will no longer work at the club. The owner, who usually dresses as a woman, dresses as a man for a very important business meeting discussing his club's fate. The owner is taunted by the person he is meeting about how he dressed like a woman the last time they met.
Fabulous Tata Burlesque. All dressed up like a man for the occasion. Oh, I see. You got on a little cheap suit, so today you think you a man.
The owner then tells the staff that things must change to keep the business afloat and explains that he is cracking down on employees. An employee lies about why she is late, but the owner comforts her instead of firing her. Love at first sight between a handsome young bartender and starlet as they bond over grandparents in the stockroom. The owner learns antagonist is plotting a takeover of the building so he can have the valuable land for casino development. The following descriptions occur in the middle of both SKC and P Valley. The owner is verbally assaulted and called a he-she freak by antagonist due to his lifestyle choices. The owner has had to endure homophobia and down-low relationships all his life. The antagonist hires an inside man to help with the club casino takeover. The inside man is reluctant and falls in love with club employee. Each dancer goes through individual crisis fighting poverty while caring for young children. A dancer L decides to leave the club to open a new business. A dancer attends church, paying tithes to heal from demons created by strained relationships with religious parents. New lovers fall out of love because of a gun incident. The owner brings the staff together in a huddle to announce the closing and last night at the club. The owner tells each employee how important they have been to the club. The owner reminds them that this is not the end, but the new beginning. The mood is somber yet positive. The following list of descriptions occurs at the end of both Soul Kittens Cabaret and P-Valley. The ex-husband of one of the dancers comes to the club and grabs a co-worker by the neck. Gunfire ensues, and everyone thinks the owner was hit. People dress up for a funeral, but instead of a funeral for the owner, it's for the closing of the club. The entire staff and community are present. The antagonist shows up wearing a fedora and carrying a flask to taunt the owner and his employees after they lost the club. A female employee that no one liked was working undercover and saved the day, ends up owning the club. They celebrate that the owner can continue his business of running an erotic club. As an ordinary observer, I see enough in this list of similarities to go to trial.
The similarities here are not just so common that every one of them necessarily flows. Let me give you a couple of examples. There is, and I want to further address in this example how the district court erred in not honoring the rule that the tie ball goes to the non-movement on summary judgment in cases of substantial similarity. In this case, wherever there was an opportunity for him to draw an inference in favor of the non-movement, not only did he choose between A and B, he found a C. Okay?
The law says these decisions are supposed to be left to a jury, also known as an ordinary observer, but even with these images, videos, the expert, even witnesses to access Lionsgate may have had to the plaintiff's materials. The courts didn't seem to view this in the light most favorable to the non-movement.
The comparisons do suggest there may be a genuine issue of fact that warrants jury deliberation. If courts dismiss these cases based on technicalities or narrow interpretations of protectable elements, it can feel like the bar for infringement is set so high that meaningful disputes never make it to a jury. This dynamic underscores ongoing debates about fairness and accessibility in copyright litigation. But we aren't the judges, so let's continue to watch and unpack their decision.
So, for example, we highlighted three points in our brief, and I'll give you a bonus one here in oral argument. There is, we have in both works, the owner of the club is an African-American LGBTQ person. There's 4 or 5 core dancers, one of whom is a queen bee, and we have the newbie dancer arriving. It's established that this newbie dancer comes to the club carrying nothing but a red vintage suitcase. She's shy about her body. She gets the job. There is the the owner of the club is fending off closure from the local casino. They could have chosen anything other than a casino, but that's the issue that was involved in both works. Judge Wilson here gives short shrift to the casino element in our work, P-Valley, saying it was only a minor element. Our expert refutes that. He says, no, the casino element is indeed an important plot arc. And I'm not sure where...
Well, why, counsel? I mean, and this goes back to what's being repeated by the expert versus your arguments, but the casino development plot point in P-Valley runs through the entire first season. It seems to be a fleeting reference, and it was difficult to surmise where it came from because it wasn't very clear in the briefing. But it seems to be just a passing reference in the play, in the movie. How does it figure prominently in your view in SKC?
Because it is a prominent line in SKC. The takeover is not minor. And perhaps if you just Control F for the word casino in SKC and see it a couple of times, you think it's a minor plot line. And I think the district court, frankly, just adopted the contention of the appellees. But if you were to actually study both works, actually watch all of SKC, you'll see that it is indeed a major plot line. But that's, again, another example of how the court just didn't draw the inference to the non-movement.
So how many times did the casino How many times was it referenced?
I couldn't tell you that. I mean, it's.
I mean, you're here trying to dispute that there are no tribal issues of fact. So, and your contention is that this is a major plot point. So, can you back it up with some references to the record?
At the moment, not specifically.
Okay.
I could just tell you that it is woven throughout the entire thing. It is not a fleeting reference.
When a stage play briefly references a casino plot perhaps only once or twice, it may seem like a minor detail on the surface. However, in the focused world of theater, even fleeting mentions hold weight, driving the story forward by hinting at themes or issues that unfold within the core dramatic framework. Unlike a TV series, a play has limited time and space, so its storytelling centers on a specific conflict or a small set of characters. As a result, the play may reserve only a few precious lines to highlight the casino storyline, weaving it subtly into the plot without diverting attention away from the main action on stage. In contrast, an episodic television adaptation can explore that same casino premise in far greater detail, turning a single mention into an entire subplot or even multiple episodes. In Soul Kitten's Cabaret, the casino plot was established at the beginning of the play, and it drives the action and intention of the antagonist. His entire role in the story motivated by the casino development. As evidenced in the following clip, the contentious meeting between Tata and Frank establishes the casino plot from the beginning of the play and is the antagonist's driving force.
I know why you want this place so bad, Frank Jr. I know about the casinos they're trying to build, and I know how much money this land is worth.
A derivative work made into a dramatic TV series like the one Nikki allegedly pitched to Lionsgate would definitely mention the casino multiple times throughout the season.
And how else did the district court sort of look at this with a jaundiced eye against your client?
Sure. So, for example, the LGBTQ African American club owner, the district court gives a lot of skepticism to that similarity, saying that, well, one is non-binary and one is gender fluid. And are those differences important? Yes, in general. But for purposes of what we're talking about here in substantial similarity, that's not what we should be talking about. When the district court chides us by saying that, well, we allege that the newbie dancer arrives by a taxi cab in P-Valley, in SKC, and a bus in P-Valley, the district court says, well, you're mischaracterizing the evidence because that's not public transportation. But, Your Honors, I would submit to you that if we're quibbling about the definition of what is and is not public transportation, that is not what the district court is supposed to do.
Well, but even
before your time is up, I would like you to address what I see as a problem for your side of the case, and I'd like to hear your response to it. To me, the themes, the dialogue, the mood, the setting, and the pace could not be more different between your client's protected work and P-Valley, which is dark and violent and all about domestic violence and the place of religion and a bunch of things that have nothing to do with SKC.
I wouldn't consider a story about an erotic dance club in a bankrupt inner city at risk of being taken over by a casino staffed by women who can barely take care of their children, one of whom was the product of SA, a lighthearted story. The expert's report is essential because, in this situation, it could offer some insight into the judge's question about P-Valley being darker than SKC.
So, just taking a step back, why are these sort of what I view as smaller things sufficient to overcome those huge dissimilarities?
I would disagree that they are so strikingly different. I think perhaps the opinion of Judge Wilson says that, but this is again where the judge.
We have de novo review, but I'm asking you why my view is wrong.
Sure. Well, I'd point again to the expert opinion, which again is not a rubber stamp of just what our client says. They give extensive examples of what is similar. You pointed out religion is the same. Religion is not an important component of P-Valley. That's in the district court's opinion. But then again, that's an inconsistency because in the opinion itself, In the very next sentence after the district court says that religion is not an important feature in SKC, it goes on to say that religion is indeed a feature in SKC. It is internally inconsistent.
You don't have to quote the Bible scriptures to me, okay? My mother did that for 18 years of my life. But it keep her from tearing me down every chance she got.
As you'll see in the following clips, Soul Kittens Cabaret has themes of addiction, domestic violence, mental wellness, and even gun violence.
Your $2 hoe just went up to $2 million.
You trying to make a fool out of me?
No, I'm not.
You trying to take everything I work for?
No, I'm not. Please. Let that baby go.
There are limitations because we watch the action play out on a stage versus a TV series, where lighting can be more dramatic and stylized.
Let me give you one more example. And this typifies the district court's error, okay? There's a scene where the newbie dancer goes to change in the restroom at the beginning of her career in this strip club movie. Changing in the restroom in this kind of modest context is a little bizarre, right? Because it is a strip club. They're in the back with all the girls, okay? The district court does two things. One, he disagrees with our characterization that the character in SKC changed in the bathroom, notwithstanding the fact that in the record there is, quote, I'm a little bit shy about my body. Can you show me where the bathroom is? So, of course, she's changing in the bathroom in SKC. Then in P-Valley, the district court goes on to say she changed in the bathroom not because she was modest, but because she had to hide a gun and down a bottle of alcohol. By the way, that bottle of alcohol was a miniature. She took 2 sips of it. But in the play, in P-Valley, one of the other dancers says, she's been here a week. What has she got to be ashamed about? Of course, modesty is the issue for both characters in that scene. Yet the district court, instead of choosing between A and B, he went out of his way to find C, a different interpretation, a preconceived notion that these things are dissimilar, which is not supposed to be the focus. He's supposed to be focusing on what we allege are the similarities, taking as true our allegations, and did not give, on summary judgment, the non-movement, the inference that we deserve.
You're running into your rebuttal time. Let me see if my colleagues have any other questions before.
No, not now.
Okay.
Not right now.
We'll
Thank
give you a little bit of extra time for rebuttal.
Thank you.
Okay.
I have to say, despite the plaintiff's counsel being in excruciating pain, he did a great job of sticking to the facts and bringing it back to the expert report, and how the district court abused its discretion by striking the expert and not considering the evidence in the light most favorable to the non-movement.
Good morning, Your Honors. May it please the Court, my name is David Halberstatter, and I'm appearing on behalf of the appellees. Your Honor, just because appellant and appellees disagree about the accuracy, the validity, or the significance of appellant's comparisons of the works does not mean a material factual dispute over substantial similarity exists. In fact, if that were the case, summary judgment would never be appropriate on substantial similarity grounds because the adverse parties always disagree about the claimed similarities. Rather, it's the works themselves that control, not what the parties say about those works. And it is the objective evaluation of the works using the extrinsic test that determines whether a reasonable jury could or could not find the works to be substantially similar in protected expression. The district court engaged in that objective evaluation. It reviewed the works. It carefully identified the elements of plot, theme, dialogue, mood, setting, pace, and characters that were unprotectable. It filtered those elements out of the analysis. The district court then compared what was left, the protectable expression in the works. The court found that a number of the 57 purported similarities that appellant identified were actually not based on any of the 3 Soul Kittens Cabaret works that were in issue. By appellee's count, there were at least 10 of those. The district court found that a significant number of the remaining similarities were the result of appellant's mischaracterizations of one work or the other or both. By our count, there were at least 10 or 11 of those as well.
This statement by the defense could be considered mischaracterization. The materials referenced in the appellant's comparisons were included in the declaration of facts submitted to the court. The assertion that they were not properly cited or included is factually inaccurate. Copyright protection attaches to a work automatically upon its creation and fixation in a tangible medium of expression. The Copyright Office registration is not required for the work to be protected. Registration of materials with the Writers Guild is evidence of authorship and creation date, which can be used to establish copyright ownership in court.
The district court then found that appellant had made still other alleged similarities seem similar by taking particular elements out of context and describing them generically when the actual expression was markedly different. Based upon its extensive and thorough analysis, the district court concluded that no reasonable jury could find substantial similarity between the work's respective plots, themes, dialogue, mood, setting, pace, and the characters.
It would be helpful if you could address for me the issue of the expert declaration and why the expert's career, his 30-year career, was not sufficient to qualify him as an expert.
Certainly. Well, to answer that narrow, specific question, there are a lot of people in the entertainment industry who read scripts as part of their job. And if they've had a career as long as this expert has, they've probably read thousands too. But that doesn't qualify an individual to opine on substantial similarity if they don't have any background in literary analysis, literary criticism, or even as part of their job comparing works for this specific purpose.
Counsel, is there a case that says that an expertise in literary analysis and criticism is a prerequisite for this type of expertise?
Well, I would say, Your Honor, that this judge, Judge Wilson, in Gable, reached that conclusion in striking the expert testimony of Professor David Nimmer, who was a well-recognized scholar in copyright but had no expertise in literary analysis, and this court affirmed that exclusion. So I don't know that there are any other cases that would support this, but
we're talking about literary works here where, obviously we have script to movie. In this case, in Astor White, we had treatment to television series that had gone on for years. And
Your Honor,
I think it's kind of hubris for a district court judge to think they have enough knowledge and basis in film and theory, things that people go to school for, USC, UCLA, to learn all about, that they can just decide this on just a dismissal stage, except I think in rare cases where it's just obviously so frivolous.
But you're relying on the abuse of discretion standard of review.
yes, very much so.
The abuse of discretion standard is a legal principle used by appellate courts to review decisions made by lower courts, judges, or administrative agencies. It evaluates whether the decision was unreasonable, arbitrary, or based on legal or factual errors. A decision constitutes an abuse of discretion if 1. It relies on incorrect legal principles. 2. It is based on clearly erroneous facts. 3. It is unreasonable or outside the range of acceptable choices.
This standard is highly deferential, meaning appellate courts are reluctant to overturn decisions unless there is a significant departure from proper reasoning or fairness. It is commonly applied in reviewing evidentiary rulings, sentencing, or administrative actions.
In fact, as this court knows, expert determinations lie peculiarly within the sound discretion of the trial court, and reviewing courts afford the trial court a high degree of deference. So for this court to overturn the granting of the motion to strike, it has to be firmly convinced that the district court decision lies beyond the pale of reasonable justification.
Let me ask this. Counsel pointed out that expert opinion can be helpful in letting courts sift through an objective test. When is it useful in some circumstances versus this one? Why was this not one of those instances?
Well, first of all, Instances in which an expert witness on prior art, for example, could be relevant is if there is a significant body of pre-existing works that employ similar elements of expression and so forth, and an expert who is fully knowledgeable in that prior art, not someone like Mr. Aft who watched 3 other films. Someone who is knowledgeable in that prior art might be useful in identifying factors that might otherwise on their face seem to be protectable expression, but which are in fact common tropes for a genre. But that's not this case.
If a judge can't do a comparison on the paper that he or she has, then, and because there has to be expert testimony, then it's kind of a nice way of saying all these cases are going to have to go to trial.
Well, not necessarily, although we think this case should go to trial, because on summary judgment, we can bring in evidence of experts, and we can at least hope that the district court will consider. In this case, the district judge made the decision, much as in Astor White, as you will read the concurrence says, without even an argument by the lawyers. So the judge doesn't simply decide the facts, and this is a fact question. Substantial similarity is a fact question on this court's law. And the judge decides the case, doesn't hear from experts, doesn't want to hear from jurors, doesn't even want to hear from the lawyers. Just simply makes a decision in chambers about something that's as sensitive and delicate as literary equivalence.
What rule? I mean, we don't. So it's only recently that we have this situation with district court judges sitting in their chambers with no expertise or knowledge of the film industry whatsoever, not even having the benefit of argument from counsel, and deciding things on a 12b6 motion when the standard is plausibility. Should we develop a rule that simply should not occur? We should prohibit dismissals based on substantial similarity under those circumstances. I mean, there has to be. I mean, I look at this case and I look, at Astor White, and there must be some cases that are just so frivolous that they deserve to be dismissed at the 12b6 stage for failure to plausibly state a claim. But then there's others where it begins to get grayer. And I'm just seeing district courts just disposing of cases on the easiest ground available. And I think it's troubling me, but I don't know what rule is the right rule to have. I mean, Nimmer says, and I've always agreed, that even on grants of summary judgment should be extremely rare in this kind of a case. So grants of summary judgment are, a much higher standard that you have to meet than just plausibly stating a claim. That aspect of this case, counsel, really troubles me. I do not want to encourage district court judges to do this.
That's not this case.
What if we were to disagree with you about the ruling concerning the plaintiff's expert? What would be the result of that? Would we have to remand, or would we simply consider the expert's declaration as part of our de novo analysis of substantial similarity?
Thank you, Your Honor. I do not believe that well, first of all, let me say that before responding to that question, and I will, it does not matter whether any of the members of this panel, had they been sitting at the district court level, would have ruled differently. That's not the test. The test is whether or not the judge.
My question is a different question. I want you to assume, for the sake of my question, that we think the district court was wrong. Then what?
I do not believe it would be necessary to remand. I think that this court, reviewing the record de novo, has the report as part of the record, and it could review the report and accord it what weight this panel thinks it is due.
But if we look at what the plaintiff's expert testified to, he testified to a similarity in the fact that there were cords that were broken. He admitted, and our expert showed, and the
He may have been the worst expert in the world, but he did testify that that Led Zeppelin's song infringed the deposit copy, did he not?
He was comparing it to the deposit copy. On the motion for summary judgment, he compared it to the studio recording.
Right, but at trial, which is what we don't care about denied motions for summary judgment, we don't review them.
Right.
At trial, he testified that it infringed the deposit copy. He may have been the least believable expert in the world. He may have, but we can't reject his testimony because he was impeached, can we? Isn't that for the jury?
I would add that I don't believe, had the district court considered the expert report, that it would have changed anything, because the expert largely parroted appellant's comparisons, which the district court found repeatedly to mischaracterize the works.
It is entirely possible for an expert to arrive at the same conclusion as the plaintiff's allegations. The key distinction lies in the use of the Daubert methodology and extrinsic analysis. Inferences from the facts are jury functions, not those of a judge ruling on a motion for summary judgment. Striking the expert report and dismissing the case improperly encroached on the jury's role. The court's role is limited to determining whether there is a genuine issue of material fact for trial. It is not the court's role to assess the credibility or persuasiveness of evidence, including expert testimony. Determinations about the weight or credibility of evidence, including whether an expert's testimony is parroting or lacks originality, fall squarely within the jury's domain. Even if the expert's report appears weak or derivative, it should be for the jury to decide its credibility and impact.
Striking the expert report for parroting improperly required the court to assess the credibility and substance of the expert's conclusions, a function reserved for the jury. Even if the expert report was not compelling, it raised a genuine issue of material fact sufficient to survive summary judgment. The court should have allowed the jury to weigh the expert's testimony against the other evidence, rather than preemptively dismissing it.
Have I answered Your Honor's question?
Yes, thank you.
Thank you. So, there are a couple of things that I wish to stress. Well, first, the similarities that appellant alleged existed between her Soul Kittens Cabaret works and Appellee's television series P-Valley, in my view, were even less compelling than those in the seminal Ninth Circuit decisions in which this court affirmed summary judgment for the defendant appellee on substantial similarity grounds, without, may I add, any expert testimony. Those other cases include Litchfield versus Spielberg, Burkich versus Crichton, Kauf versus Walt Disney, Funky Films versus Time Warner, Benet versus Warner Brothers, and Gable versus National Broadcasting Company, and many others. In all of those cases, the court reviewed the works themselves, just as the district court had done, and without expert testimony, it consistently found, just as the district court found in this case, that many of the comparisons made in those cases involved unprotectable ideas, stock elements, stock characters, that the claimed similarities mischaracterized one or the other of the works, such as the works were not actually similar in their protected expression, and that any remaining elements were nothing more than random similarities scattered throughout the works and or different expression of common unprotected ideas and themes. In my view, the significance of appellant's completely false comparisons cannot be understated. Appellees pointed out in their answering brief that at least 10 of appellant's claimed similarities between SKC and P-Valley were not based on SKC. Rather, they were based on a different work by the appellant, a TV pilot script called Curtains, which may have been based upon Soul Kittens Cabaret, but it is not a registered work and it was not a subject of appellant's infringement claims.
The defense attorney's statement that some materials were not copyrighted is legally incorrect. As soon as appellant fixed the materials in a tangible form, they were protected under federal law.
Correct. and by dismissing comparisons based on an erroneous assumption about copyright status, the panel improperly filtered out evidence that should have been considered in the substantial similarity analysis. Filtering out evidence of similarities based on an incorrect assumption undermines this principle and deprives appellant of a fair adjudication. In this case, appellant's declaration states she left copyrighted materials with the CEO of Lionsgate, creating a specific channel of communication. The CEO having a lack of recall is not a denial of access, but a factual dispute appropriate for jury resolution.
They did it again today by referencing the scene in which the dancer arrives by public transportation. The public transportation element is not present in any of the SKC works that are at issue. It was included in the Curtains script, but not in the scripts at issue. There's no question or dispute about this. Plaintiff's own comparison video clearly shows the source of these 10 purported similarities as being from Curtains. But appellant did not withdraw these claimed similarities on appeal. Rather, she just doubled down. Likewise, the significance of appellant's blatant mischaracterizations of the works also cannot be understated. Throughout its order, the district court identified comparisons that mischaracterized one work or the other in order to manufacture a similarity. And even when it didn't call out appellant expressly, it was implicit in the court's repeated findings that one element or another was expressed differently as between the works, and that, such that appellant's comparisons were actually disingenuous. And they're doing it again today.
Something that I find interesting as I watch Nikki Gilbert's case against Lionsgate is how substantially similar the defendants in the argument are to the defendants in other cases, like Zindel versus Disney. Take a look.
The only thing that these works have in common is that it's a cleaning lady bonding with an animal who she attempts to have escape. What happened here, what the district court did, and I definitely want to discuss, Judge Wardlaw, your concerns with motion to dismiss.
Well, I understand that the defendants in these cases, the people who you're representing, the institutions, the producers, the creators, they want to get rid of these things immediately. I practice enough in this area that I completely understand, but I do worry about the situation, and we don't have a published opinion. All the history of the Ninth Circuit, we do not have a published opinion affirming a dismissal at Rule 12b6 stage on substantial similarity grounds. And I would say it should be limited to the most frivolous of cases, because the standard at the Rule 12b6 stage is plausibility.
That doesn't mean, plausibility does not mean the most possible frivolous case.
No,
it means
it doesn't,
exactly
but have
that.
they
It must
plausibly
be plausible.
stated a claim? And if you're looking at a script and a movie, I don't know, I mean, under what circumstances could you say that they had not plausibly treated a claim?
Can I ask this, counsel? In terms of the comparison of Tata Burlesque from SKC and Uncle Clifford from P-Valley, there's I guess a dispute between the sides as to whether gender fluidity versus a gay male character is a notable distinction or could be grouped together. Can you speak a little bit to that point?
Well, sure. I would, I'm not in either category, but I imagine that if I were a gay man, I would consider gender fluidity different. And similarly, if I were a gender fluid individual, I would probably react to being characterized as a gay man.
Well, counsel, there's also the distinction in the way these are expressed in terms of their identities. I mean, Tata doesn't have, long silver nails and some of the other things that occur with Uncle Clifford.
Yes, that's correct. The Uncle Clifford identifies as female. He wears predominantly female clothing. I believe there's maybe one scene when he was going to a bank where he took off his nails and dressed as a male. Uncle Clifford uses exclusively feminine pronouns. Tata Burlesque, by contrast, dresses like a male, refers to himself with male pronouns, and is an entirely different character.
Okay. I'm sorry, Mr. McVale or Miss Burlesque. I just get a little confused sometimes because don't you dress up like a woman sometimes?
In her upcoming book, Nikki vs. Goliath, The Cost of Justice, Nikki addresses the distinction between Tata Burlesque and Uncle Clifford. Nikki says, and I quote, "The court took it upon itself to judge the nuances of representation, love, and gender identity as a matter of law. The intimate, interpersonal relationships between two people in the LGBTQIA community are both complex and deeply nuanced, defying attempts to fit them neatly into predefined categories. This complexity is reflected in the LGBTQIA acronym, which encompasses a broad spectrum of identities and experiences. It is not a definitive explanation of what love and gender identity are, but rather a testament to the diversity of human connection. For the judges in my case to take it upon themselves to determine that substantial similarity did not exist between my character Tata, which is French for anti-burlesque, and Uncle Clifford from P-Valley, by deciding, as a matter of law, that the distinctions boiled down to superficial details like nail length, hair color, or the amount of makeup and liquid liner worn, was a gross oversimplification of complex narratives. Their ruling failed to account for the layered originality and depth of the characters and dismissed the lived realities that these characters sought to amplify."
Have I answered your question, Judge Sanchez?
You did. I mean, what I'm thinking about is what level of specificity would we need to get to in this context, for example, because there aren't that many stories about an LGBTQ related owner of a cabaret or nightclub. And so we could slice it further down, and I take your point that there are these differences, but is that necessary for the sufficiently similar analysis?
No, it is not necessary, Your Honor, because there are many other differences, including how each of those characters came to own the club, how those characters could potentially lose their club, how those characters interact with the dancers at the club, how that character interacts with the antagonist, and so forth. So there are so many differences in the expression of each of those characters and what they do and their role in the story that you don't really have to
parse that piece of it out.
Correct.
Both Tata Burlesque and Uncle Clifford occupy spaces that highlight the intricate dynamics of being openly queer while navigating relationships with men who prefer to remain on the down low. These relationships are fraught with societal pressures, stigma, and secrecy, creating a narrative ripe for exploration. In my work, Tata's down-low lover profoundly shapes Tata's arc, while in P-Valley, Uncle Clifford's relationship with a closeted man is ongoing and central to the plot. These differences in resolution are not a matter of whether one is more gay or authentic than the other. They are creative choices that reflect the spectrum of experiences within LGBTQIA communities. Reducing these rich narratives to questions of nail length or hair color erases the cultural and emotional weight of the characters they represent. It is an act of legal dissection that prioritizes dissimilarities over thematic resonance and shared humanity. Worse, it establishes a precedent where courts armed with limited understanding and lacking professional expertise in gender studies or queer representation may feel empowered to decide what qualifies as gay enough. Tata Burlesque and Uncle Clifford are not simply archetypes of queer representation, they are embodiments of resilience and resistance against marginalization. Both characters navigate spaces where their identities are simultaneously celebrated and scrutinized. They act as protectors and nurturers within their communities while grappling with the complexities of their personal lives. By denying the depth and intricacy of these characters, the court failed me in the underserved communities my work sought to amplify. The fact that both men are black, gay, run an erotic club that caters to straight men makes them both rare and substantially similar.
Do you want to take a moment to address the casino element in these cases and how much of a driver it is in the relative works?
Yes, I'm happy to. And Your Honor asked opposing counsel a question about how many times it was referenced in Soul Kitten's Cabaret. And I don't remember for sure, but I think it was twice. And it may have only been twice in one of the works and not in either of the other two. It was not a plot element at all. Further, the character who they are attributing to whom they're attributing this casino plot development, Frank, is the deceased lover of Tata Burlesque, who gave the club in his will to Tata Burlesque. And it is apparent far, far more so in all of the three Soul Kitten Cabaret works that he is driven by animus. He thinks that Tata Burlesque bewitched his father, turned him gay. I use turned in air quotes, turned him gay, and he thinks he is the rightful owner of the club, so he wants to do anything he can to get that club back. It has nothing to do with a casino development.
I know why you want this place so bad, Frank Jr. I know about the casinos they're trying to build.
This casino want to buy our land.
And I know how much money this land is worth.
You bringing a casino here shows me you remembering your peoples.
No, sir. I'm no snitch. Come on, love. Come on. Look, I can get you up to $1 million.
Fix me like we discussed.
Have I answered your question?
Thank you.
Great. So the other item, so as I mentioned, appellant has doubled down on these mischaracterizations and did it just now in his oral argument. The appellant's counsel focused on the shyness, the purported shyness of the new girls in each work by focusing in P-Valley on what the other dancers perceived Autumn to be doing while she was changing in the bathroom. She was not changing in the bathroom because she was shy. She was changing in the bathroom because she was checking her weapon and having some alcohol.
1 week later, and this bitch still changing in the styles? Like, what she got to be shamed about?
The other dancers obviously didn't know that because she was changing in the bathroom. And so they wondered why, how could she be, ashamed of her body at this stage? But it's not the same as Brandy in Soul Kitten's Cabaret, who was genuinely shy about her body and was changing in the bathroom because she was shy about it. That was a perfect example of how appellant had mischaracterized what one work or the other to make them seem similar when they were not.
It is crucial in copyright infringement cases, especially when evaluating substantial similarity between characters, that judges and attorneys do not unilaterally decide whether a writer's characters have been mischaracterized. First, this assessment is inherently factual and requires an expert's specialized insight or a jury's balanced evaluation. Entrusting judges or opposing counsel with the sole power to determine a mischaracterization risks subjective or biased decision-making, inadvertently shutting the courthouse door to valid claims. If courts allow defendants, or even judges, to define what counts as a mischaracterization, it creates a dangerous precedent that effectively renders the plaintiff's own creative intent irrelevant. This results in a near impossible standard for plaintiffs to overcome, as key questions about the character's essence and unique traits would be decided without the guidance of an impartial fact finder. Ultimately, leaving these detailed fact-based inquiries to expert testimony and jury deliberation upholds fairness in copyright litigation and protects authors' rights.
Before you wrap up, can you address the Metcalf point and what, even if you have unprotectable elements, if they're arranged in a certain way that creates a substantial similarity, is there a triable question as to that issue?
Yeah, no, there is not. First, I will note for the record that appellant in her opening brief does not argue that the district court misapplied the test. She argues that the court neglected the test, which obviously isn't true because the order granting summary judgment spends 2 pages considering that test. It does not create a tribal issue of fact because, as the district court had noted throughout its opinion, the alleged similarities, even in unprotectable elements, were based on mischaracterizations of one work or the other. In fact, the entire comparison analysis was plagued with mischaracterization, and correctly concluded that the selection and arrangement of these unprotected elements in no way approached the level of similarity present in Metcalf. I will add that, in Metcalf, this court found each major extrinsic element in the allegedly infringing work to be substantially paralleling the allegedly infringed work, and it found that the similarities in the selection and arrangement of these unprotected elements was striking. I would submit that there is no such similarity in the unprotected elements in this case, much less a striking similarity between the selection and arrangement of those elements. And I see I have finished my time. If you all have any questions, I'm happy to answer them. Otherwise, thank you for listening.
No other questions. Thank you, counsel.
A reasonable juror could examine the following list and decide whether it is close enough to the same order and arrangement to pass the Metcalf test. Remember that each description occurs at the beginning, middle, and end of both, in almost the same order, despite one being a 2-hour stage play and the other an 8-episode TV series. In the beginning of both shows, a lean, wiry, shy, new girl carrying a vintage red suitcase arrives by public transportation. She checks into a seedy motel and needs to find work, so she heads to an erotic dance club to audition for talent night. The new girl is a mediocre dancer but hired on the spot. She is not dressed appropriately. The gender-fluid owner points her to a rack, where another employee hands her a skimpy outfit. The modest erotic dancer changes in the bathroom. Other dancers taunt her. The new girl keeps a secret life back home and doesn't disclose her true self initially. The owner is looking for a replacement for a veteran dancer who will no longer work at the club. The owner, who usually dresses as a woman, dresses as a man for a very important business meeting discussing his club's fate. The owner then tells the staff that things must change to keep the business afloat and explains that he is cracking down on employees. An employee lies about why she is late, but the owner comforts her instead of firing her. Love at first sight between a handsome young bartender and starlet as they bond over grandparents in the stockroom. The owner learns antagonist is plotting a takeover of the building so he can have the valuable land for casino development. The following descriptions occur in the middle of both SKC and P Valley. The owner is verbally assaulted and called a he-she freak by antagonist due to his lifestyle choices. The owner has had to endure homophobia and down-low relationships all his life. The antagonist hires an inside man to help with the club casino takeover. The inside man is reluctant and falls in love with club employee. Each dancer goes through individual crisis fighting poverty while caring for young children. A dancer L decides to leave the club to open a new business. A dancer attends church, paying tithes to heal from demons created by strained relationships with religious parents. New lovers fall out of love because of a gun incident. The owner brings the staff together in a huddle to announce the closing and last night at the club. The owner tells each employee how important they have been to the club. The owner reminds them that this is not the end, but the new beginning. The mood is somber yet positive. The following list of descriptions occurs at the end of both Soul Kittens Cabaret and P Valley. The ex-husband of one of the dancers comes to the club and grabs a co-worker by the neck. Gunfire ensues, and everyone thinks the owner was hit. People dress up for a funeral, but instead of a funeral for the owner, it's for the closing of the club. The entire staff and community are present. The antagonist shows up wearing a fedora and carrying a flask to taunt the owner and his employees after they lost the club. A female employee that no one liked was working undercover and saved the day, ends up owning the club. They celebrate that the owner can continue his business of running an erotic club.
And we can add 2 minutes for rebuttal.
Thank you, Your Honor. Let me jump right into this. There was much talk about mischaracterization, which is really kind of hard to hear because it's just untrue. And you have to look no further than the record itself. Let's take that bathroom example where counsel said that we mischaracterized the record, and so did the district court. Go ahead and look at 2ER 171 and 2ER 216. If we're parsing out whether the characters were modest and shy about their bodies, and that's the reason for them going to the bathroom to change in the back quarters of a strip club, look for yourself. But this tripartite disagreement between appellants, appellees, and the district court, that crystallizes how we have differing interpretations of what both works meant at the time. That is the province of the jury that the district court in this case violated. Okay? Let me speak to the expert issue. We cited a law review article that was an empirical study on substantial similarity analyses, and it says it is folly to expect judges to be familiar with and understand the nuances of any given field, including those such as literature that we often falsely imply are not as complicated as computer software architecture or others. Look at the Hanagami case. This is a Judge Wilson case that was reversed by Judge Pays just a month before our case was rendered. In Hanagami, Judge Wilson gave short shrift to the complexity of the dance and also to the length of the work at issue relative to the work as a whole. The Ninth Circuit reversed and said that's not the analysis. You have to look further at the elements. Just because it's too short and too simple in your mind, that's a judgment call. This is something where expert testimony might be helpful, and that's what the district court said. When I was growing up listening to rap music, my parents would say, "Why are you listening to that? Every song sounds the exact same thing." And I would retort to my dad and say, "Well, all the country music you listen to sounds exactly the same." And his response would be something along the lines of, "Well, are you talking about country or are you talking about Western?" And this goes to show that you just viewing things from a wide circle and not being familiar with the works themselves. I think district courts, and Judge Wilson in particular in this case, assumed too much to think that he had the requisite expertise to view the substantial similarity in this analysis.
The estate of Paul Zindel sued Fox Searchlight and director Guillermo del Toro, alleging The Shape of Water infringed on Zindel's play Let Me Hear You Whisper. A district court dismissed the case, ruling there was no substantial similarity. Former Ninth Circuit Judge Alex Kaczynski then joined the Zindel estate and successfully appealed. Take a look at his closing argument, which mirrors that of the plaintiff in this case.
Dismissal of a complaint for lack of substantial similarity before any discovery is virtually unheard of. Indeed, this court has never affirmed the dismissal of a case alleging infringement of a literary work without discovery and a published opinion. That's not me speaking. This is from a concurrence in a decision by this court last year, reversing the very same district judge who dismissed the case here. It suggests why it is not only unwise, but even a denial of due process to deny a plaintiff the opportunity to present evidence. You know, it used to be that this court said rarely grant summary judgment. It wasn't even thought of. The idea that you would dismiss without a chance to put on evidence, without a chance to examine the defendants about what it is they in fact took, without putting in experts, in a way it's a denial of due process. This looks to me like the heart of the story was taken by The Shape of Water. I would think that they would want to clear that up. With so much commentary about it, with Oscars having been given, having been nominated for an Oscar for a Best Original Play, not adapted play, original script rather, I would think that they would want to have a chance to say, no, we didn't sit there with that script and steal the best parts of it. I would think that they would relish the thought of going before a jury, telling their stories, and hoping to be vindicated, and basically clear their Oscars of disdain.
The case was remanded for further proceedings, ultimately underscoring that copyright disputes involving creative works often require expert or jury evaluations rather than early dismissal.
I don't think Judge Wilson is an expert in the niche strip club genre. I certainly am not. But Robert Aft had reviewed several works, went through every single one of the Ninth Circuit's elements of substantial similarity and found that they were indeed substantially similar. Again, I can't highlight enough that in the Ninth Circuit, substantial similarity and on summary judgment is very narrow. The balls and strikes need to go to the non-movement. The district court didn't do that here. He went out of his way to find in favor of the movement with the preconceived notion that there was no substantial similarity. Further, just for the same reason...
Start to wrap up, counsel.
Sure. For this is the last point I'll make. For the same reason that, and the Ninth Circuit has said, just listing a bunch of random similarities should be discounted, so too should be the list of dissimilarities. I can count 1,000 dissimilarities between the works. That doesn't mean that both works aren't substantially similar. Look at the Ninth Circuit's case in Alfred. It noted that the script versus the movie, there are striking differences. And there might be here too. That doesn't mean that they are not substantially similar for purposes of copyright infringement in the Ninth Circuit.
Okay.
Thank you, Your Honors.
Counsel, thank you both for very helpful arguments. The matter will stand submitted and court is adjourned.
All rise.
This court for this session stands adjourned.
10 days later, on December 16th, just 9 days before the Christmas holiday, the panel affirmed the district court's summary judgment motion, ruling her case would not proceed to trial.
In addition to questions of due process, this ruling by the appeals court conflicts with recent rulings concerning expert testimony, which means this could signal the need for more clarity with the courts. The case involves alleged copyright infringement between Gilbert Daniels' Soul Kittens Cabaret and the television show P-Valley. Despite similarities in characters, themes, and plot elements, the lower courts ruled in favor of the appellees on summary judgment.
This case is ripe for rehearing en banc for the following reasons. To ensure uniformity in copyright law, the panel's decision deviates from binding precedent Metcalfe, misinterpreting the substantial similarity standard by requiring a stricter, strikingly similar threshold. This sets a problematic precedent that undermines the protection of creative works. The exclusion of expert testimony contradicts Ninth Circuit precedents that recognize its importance in analyzing complex creative expressions, such as screenplays and film works. To clarify summary judgment standards, courts must refrain from removing fact-intensive questions, such as substantial similarity, from the jury's purview. Misapplication of these standards erodes plaintiffs' ability to seek redress for valid copyright claims. To highlight the broader implications for copyright holders, the panel's ruling risks creating an overly narrow interpretation of protectable expression, potentially making it nearly impossible for copyright holders to prevail in infringement cases involving derivative or complex works.
It's clear that both Nikki and her legal team remained committed to her cause and how her story might shed light on the challenges independent creators face. Nikki is seeking a few high-profile amicus briefs to support her fight, which she plans to take to the Supreme Court. And that concludes our WRF TV special report on the high-stakes litigation of independent creator Nikki Gilbert Daniels versus entertainment giant Lionsgate.
Nikki is currently appealing the six-figure judgment that Judge Stephen Wilson imposed, an amount judges typically reserve for cases deemed frivolous.
While many disagree with that assessment, the harsh financial penalty serves as a stark warning. Underfunded plaintiffs should brace themselves for potentially devastating losses when seeking their day in court against powerful defendants. For WRF News, I'm Clarence Mack.
I am Helen McDuffie.
Thank you for watching WRF News, news worth sharing. Please remember to like, share, and subscribe.